The biggest difference between bankruptcy and a debt settlement or debt negotiation program is the certainty involved. With a third-party agency or company that's trying to negotiate your debt on your behalf, there really isn't much certainty involved there. Creditors don't have to negotiate these debts, and as a blanket rule, some banks simply will not negotiate with third-party agencies or companies. With a debt settlement or debt management company, you're paying a pretty hefty payment towards this company each month. Most of them then don't forward those payments immediately on to these creditors. Instead, they hold on to those funds in a trust account, and once things have reached a boiling point where you're facing potential lawsuits from creditors, the company that's negotiating on your behalf hopes there's enough money in that trust to then settle these different bills. If there's not, then you're essentially back at square one, and in fact, in a possibly even worse spot, because now you're facing wage garnishments and levies.
Once a person files for bankruptcy, something called the automatic stay goes into effect, and that's by force of federal statute. I like to view the automatic stay as almost like an impregnable brick wall that's built around you that prevents your creditors from attempting to collect any debts against you. That includes garnishment. So as soon as you file for bankruptcy, any garnishments that are taking place on your wages will be immediately stopped. Any lawsuits that are in progress will be immediately halted. Any collection efforts by creditors, whether they be harassing phone calls, whether they be collection letters, any attempts to collect debts against you must immediately halt by force of federal statute. So there's great power in filing bankruptcy, and unlike other debt resolution methods, whether it be credit counseling, whether it be debt settlement, debt management, bankruptcy has the force of federal statute behind you, whereas those other processes are purely voluntary.
In our office, we pride ourselves on quality of service. We will do everything that we can to help a client through this bankruptcy process. Sometimes that means just answering questions that maybe they've even asked a couple of times before, and just making sure that they feel comfortable through the whole process. The bankruptcy process, it's one that's foreign to a lot of people. They hear this term, but they don't know much about it. So as much as it is filling out the forms, making sure that everything's prepared properly that we file with the court, it's helping shepherd these people through an unfamiliar experience. And we want to make that experience as painless and as comfortable as possible.
Chapter 7 is what I call a straight bankruptcy or a liquidation bankruptcy. Chapter 13 you can think of as sort of a repayment plan. Now, people with higher incomes won't qualify for a Chapter 7 because the court will deem that they have the means to repay some of their debt. So for some people, Chapter 13 will be their only realistic option to file under the bankruptcy code. In Chapter 13, the amount of your repayment plan is determined by your resources, your income, and your expenses. And so the theory behind a Chapter 13 is that your payments are what you can afford to pay. It's an affordability standard. Chapter 7, in contrast, is used by people who don't have the means to repay any of their debt. There is no repayment plan. A typical Chapter 7 case lasts 3 to 4 months. All of the debt is wiped out. And in certain circumstances where somebody has a lot of property, more property than we can protect under the 2 exemption menus, you may have some liquidation issues. By far, the vast majority of cases that we handle, however, there is no liquidation, and we're able to protect all of